Keshav, once it is done, you can say done. So I'll just start thereafter. Keshav, is my voice audible to you?
Please, Anjali, please.
No, I'm saying just once the YouTube live goes on, then you can say done. So thereafter I'll take the class.
Yeah, Anjali, you please start.
Okay. Hello and welcome everyone on Vestralex free online community classes on law. This is your initiative by you, for you, and only possible by the generous contribution, blessings, guidance by our seniors, mentors, and guides. Today we have Shri Amit Saxena Advocate to deliver lecture on Introduction to High Court Practice. Shri Amit Saxena is a distinguished practicing lawyer having experience of 25 plus years of active litigation in Delhi High Court. He is renowned for his active litigation in matters relating to real estate, family law, corporate law, intellectual property rights, and public interest litigations. He has an extensive practice in civil matters pertaining to the original site of the Delhi High Court. He has experience of criminal trials, inter alia, Cheating Prevention of Corruption Act, and food adulteration laws and their appeals, along with writ involving constitutional law, natural justice. He has also extensively active in arbitration matters, commercial laws, and public works law. He has also been appointed arbitrator in matters by the Delhi High Court. He is also a senior mediator with Samadhan at Delhi High Court. He fought for banning of junk foods in schools in the case titled as Uday Foundation for Congenital Defects and Rare Blood Groups versus Union of India and others. Mr. Amit Saxena is an alumni of Faculty of Law, University of Delhi. He was also elected twice as Joint Secretary of Delhi High Court Bar Association from 2016 to 2018 and 2019 to 2021. Thank you, sir, for taking your valuable time to guide us. We welcome sir and request him to kindly take over the class.
Thank you, Dhananjay.
Thank you, sir. You're welcome, sir.
Good evening, everyone. The very fact that thanks to Keshavji for actually coaxing me and pushing me to join his classes per se, and the very other fact was very scary when I'm given to understand that I'll have to take a class. So not used to that kind of a thing. Thank you, Dhananjay, for a wonderful introduction. Good evening, all the respected seniors, colleagues, and the young members of the bar. The topic was, thanks to Keshavji, was chosen as Introduction to High Court Practice. Even with my 25 plus years of practice, I do not know whether I can actually say that I am someone, some authority or something to talk about the subject High Court practice. But yes, thankfully, since the time that I joined the profession in 99 and fortunately have been part of the Delhi High Court since then. Since inception, I was the office that I was associated with, doing matters every day since then. Taking a class per se is the most difficult proposition that is bestowed or at the moment asked to conduct a class. High Court practice, the first thing today I met our younger colleagues, the first thing that they asked, sir, कि सर केस कहाँ से आएंगे? So High Court practice would be the much later stage. The first thing, case कहाँ से आएंगे? That is the first problems that we as lawyers face. Coming from a thought of old school, as I put myself in that category, I've always told people that, and my younger lawyers, for being a first generation lawyer myself, that first of all, the very basic is to join an office, to join a place where there are ample matters, may not be confined to High Court, could be the trial courts, could be tribunals, wherever. But first and foremost thing that I would I vouch for is joining up an office where there are matters, where, and rather if there, I would say both sides, where there are either a variety of matters or there's only one specialized subject. Some of my colleagues who had joined offices doing one specialized subjects have mastered their art there. So either be a jack of all trades or a master of one. So in that sense, please don't take it that no, we have to be, we are someone saying that, oh, I'm confined to just one branch of law. I today, especially the youngsters who come over, they prefer that ways. Some of the youngsters who want to join my office, they would come, what kind of matters you do? I tell them it's a mixed bag of matters. For most of them, they would say, sir, I want to do IPR only. Some of them would say, I want to do arbitration only. Maybe these are the most per se happening subjects, as they say. Some of them, most of them would come and tell me, ki, sir, criminal law. Somehow that attracts all of us, including me. Seeing all the movies, maybe seeing all the serials where they show the criminal lawyer maybe making huge sums of money as compared to the practice on the civil side. However, as luck would have had, when I joined my senior's office, it was primarily civil laws. Yes, that's what I tell them. The most hard work that is being put into civil practice, one cannot match it in any other forum, be it, and no offense to again no offense to anyone, but that is how we have been practicing on the civil side right from day one. From besides what civil law would entail, reading lot of bare acts, lot of laws involved in a civil practice, and then comes to the basic part of pleadings, drafting a plaint. So initially when I joined, it took some time to draft a plaint. After a while, we thought, oh, drafting a plaint is much easier. Then came the aspect of preparing a written statement, the most tougher part, where we were further. That is where I found that, oh, we must know more of law. Written statement, the preliminary objections, thereafter replying to the specific averments in the plaint, and then rejoinder was again the most boring part of it, to again deny all what is said in the written statement. Initially, I thought, I still do, that it is much advisable for all my younger colleagues. I would be actually referring to them primarily because anyone over and above 5 years or 10 years of practice would have actually experienced it themselves. Advisable, if they can, please spend some more time in the trial courts. Coming to high court, I always thought was much easier compared to being in the trial court, where every day the judges would straight away pull you up for non-compliance of the previous order, which was just a week ago or maybe 4 days ago. Coming back, high court practice. Younger, again, my younger colleagues, the first thing कहते सर काम भी तो हो, काम आए तो हम करें. That is where I request all of them, please join some offices where you get that exposure, where you get an exposure. Our high court, the Delhi High Court, especially one of the finest in the country, where we have exposure to not only varied branches of law, but one of the finest lawyers of the country are from the Delhi High Court. That's my take. No offense to I also have to be politically correct on that. Somebody from other high court would come and sue me. Oh, how can you say that? Be that as it may. One of the finest lawyers that we have, one of the finest lawyers as opposite counsels. We have learned a lot from my opposite counsels. Some of the basics that fortunately we could do at the trial court helped me shape up what was coming in the Delhi High Court. Yes, that it is time consuming. The In addition to the CPC and the other laws, we had to cover up the Delhi High Court rules, practice and procedure. There's another book we had to go through, why the Delhi High Court. Again, one of the exclusive ones which would have the original side to it. Another, there's so much of exclusivity that we have in the Delhi High Court or the High Court per se, be it right from the appointment of arbitrators, 11.6, only the High Court would have the powers. Being on the original side, anything above 1 CR, back to Delhi High Court. Anything above 2 CR on the commercial side, back to the High Court. On the criminal side, for all the bails, which the we all complain that the lower court or the trial judges are quite reluctant to grant. Again, we look up to the Delhi High Court, seeking the proper reliefs that we are in the criminal matters. As was also put, I remember Justice, Chief Justice of India, DYC, himself requesting the trial courts कि bail must be the rule and jail is not. That is where, and he requested the trial court judges to be more, I won't say liberal per se, but at least be more connected to the basic structure of a criminal law, that why one should be granted and why one should not be granted. That is up to, because I remember then when we started, it all boiled down to कि वकील साहब हाई कोर्ट से ले लेना बेल, तो यहाँ पे तो हमें डिसमिस करने दीजिए. And that used to be correct, because whenever we used to approach the high court thereafter, most of the times, since the case, the facts of the case, or otherwise the law as it stood then and now, we were granted the reliefs. From again, high court on the original side, the civil side, getting an ex parte injunction was much easier than in the trial courts. I remember in the trial court, they used to say, वकील साहब 2 दिन का नोटिस ले जाओ, सर्व करा के ऑपोजिट पार्टी को ले आओ, तब देखते हैं मेरिट्स ऑफ द केस. बट द दिल्ली हाई कोर्ट, I remember initially those days, we started with the court granting us interim injunctions or interim orders, and then again giving us very short dates ki yes, serve the opposite counsels and the parties, come over, we'll hear the final arguments for an IA 39(1) and 2. Coming back to the practice that so far we have shared my exposure or my experience on the civil side and the criminal side. Then comes the writ jurisdictions. So when I was told that it's a class that I have to take, I was not quite happy with the wording, because one, I don't personally feel that I can take a class on any subject. I can only share my experiences. I am no one to, so I was requesting my friends ki what to say on the writ side. Everybody would know there what all is provided in the writ jurisdiction, where do we have to approach, how do we have to go. Again, at times, however much we are in the practice, we still many other times end up thinking, oh, we know it all. So filing a case, a writ against an order against UPSC. So the matter came up before the bench, and the opposite counsel saying UPSC is not covered under the writ jurisdiction. You have to go and approach the cat. That is where you again start surfing through the pages, the Central Administrative Tribunal Act, what all bodies are covered, since I had not done that prior thereto. So, yes, even for an advertisement for jobs that the UPSC and the written examinations that the UPSC would conduct, one could not challenge it before the writ jurisdiction, stating that no, there's the alternative remedy. Rather, it is the cat before whom we have to go. Even if I was not an employee until then, I still had to give my exams, my clients, when I say I had to. There's so much that there's to learn every day. The filing section that we have in the High Court, now we all have to undergo that entire rigor of preparing that, getting it photocopied, signing it, then scanning it, then making the PDF with OCR. The technologies have advanced now, but it has helped us a lot. I would say, one of the last ones to shift to a tab or a iPad, whatever we may term it as, with the liquid text helping me. And the reason why I was forced by my friends also, we were very happy making notes, carrying the files, but then had an exposure with the liquid text, a wonderful thing that I'm now today I can say to my all my friends and colleagues that yes, we slowly will have to shift to and use the technology in our favor. The other day, I was just maybe a year back when we were told that in one of the courts in the Honorable Supreme Court, before the Supreme Court, the files, the Honorable judges were not quite comfortable with carrying that you cannot carry a file in my court, or you just have to come prepared with a laptop or an iPad or a tab, whatever it is. I was quite, I would say, appalled by that very thought. To the extent I remember in one of our meetings with the honorable judges, that is again maybe 5 7 years ago, when I was requesting them that it is on not even it is just 4 years ago, around the COVID time, when I was requesting the honorable judges ki not everybody is well conversant with the technology. Not everyone would have the facility to have two laptops or two sets of desktops, so that on in one desktop I can read my file, and the other desktop I would be appearing before the court. And in fact, the filing as it then was introduced or forced upon us during the COVID times, it was so difficult to even file even the simplest of application for a 151, maybe a change of name. Let aside other matters, they were the objections raised by the registry were the same. That is another problem that we face, that we constantly face in the courts, the objections being raised by the registry. Even maybe the last week, I had to file a petition. I was told by a colleague of mine कि sir, अब नई objections भी आ गई हैं. Earlier it used to be one blanket exemption from filing dim copies, legible copies, certified copies. Now they are given to understand the High Court practice per se has changed. We have to specify what document are we seeking exemption from filing. We have to specify the certified copy of what. We have to specify this is an illegible copy. we will produce it. All those things have now, they are more stringent on that. They seek another thing on the writ side as well as on the criminal side. The affidavits have changed. So from those basic two liners, I am the petitioner or I am the respondent, and the accompanying application or the writ is being, now we have to swear on an affidavit other submissions that we have not filed any other such petition. These are the true copies of the original. The annexures are in original. There's nothing that I've filed which are beyond the pleadings. They have, there is a change in that. On the red side, I was made to, the objections were such, and I had to actually go to the registry seeking कि सर अब तो माफ कर दो या बता दो कि क्या क्या चाहिए. They don't still, they, the templates, I'm given to understand that templates are not there, which would say कि at least these basic things have to be there on your affidavit, what you're swearing with your petitions. Same is on the criminal side. There's certain more with things which have been added on the affidavit itself. The filing of the wakalatnamas, to whom it has to be, advance service has to be made to. Initially, they would say it's a fresh wakalatnama. So that advance service somehow has taken away the joy of injunctions that we used to initially have. Now I serve them advance, so ex parte is not there anymore. So the notices are already served to the opposite party in advance. Of late, a lot is being spoken in the corridors about professional ethics and responsibilities. I personally feel one of the subjects that we all had, and none of us, including me in the college days, would have read is the Advocates Act. I had no idea that after the our enrollment with the Bar Council, we had to take a mandatorily take an membership with the bar associations. Fortunately, now the Bar Council of Delhi, past I think 2-3 years, has made it mandatory by forcing that your certificate we will issue or hand it over to you only once you come up after taking your membership with any of the bar associations, with the district bar associations or the High Court Bar Association. That was provided under the Advocates Act. Also, there are so many things that has been provided under the Advocates Act which we either have not read it or maybe we would have missed it somehow. The number of cases, I would say, against the advocates are rising before the Bar Council, especially our my younger colleagues at the bar. Somewhere the professional ethics, that thin line, is being violated. Why and how do we conduct ourselves with our clients, and also when we appear before the court? See, at the end of the day, it is, we are lawyers. We are not supposed to be personally involved in any manner whatsoever with the matters being assigned to us in our professional capacity. The moment we get personal about the matters is when we end up violating that, the line, the thin line, which was the Lakshman Rekha between the bar and the bench. We tend to, in our zeal, we end up maybe interrupting the court or the opposite counsels, or that basic respect that we used to have, especially High Court, since it is confined or to the subject itself is high court practice. Our respect towards the seniors, our the least offering our chairs to the seniors in case they are there in the courtrooms, their right to first audience, the senior advocates. We tend to, in our, I do not know, in our zeal, or maybe we have so much to say. Maybe we do not appreciate the submissions made by the opposite counsel. Leaving all that aside is what the seniors here, what we have learned from our seniors, what we learned from the seniors at the bar, and the senior judges and even the present judges. See, the judges even today they are one amongst us. They have gone from this side of the bar. They are the same set of people who have been appearing with us, against us. They're the same set of people who would just take down notes while the opposite party or the council is making their submissions before the court. We would just take our notes. And yes, thankfully, we have one of the finest judges of the Delhi High Court who would give us chance. Surely, there's no way that they are watching you. They are watching all of us. If at all something, we can always raise our hand. But yes, even otherwise, the judges will be giving us that opportunity to rebut the submissions made by the other party. Of late, this is one thing that constant interjections by the opposite councils, who it's including me, all of us on the opposite side. We suddenly feel, oh, he's lying. The other party is lying, or maybe he will get something immediately. The relief is not or is being given to him, or otherwise. The judges, the honorable judges, are giving us all the time in the world. They will hear us. They always do. I'm yet to see any honorable judge here who would not give us time to rebut. In case we feel, we can always raise our hands. Ki, your lordships, yes, I have something to say. High court practice from the time that I joined and from what it is now, I've seen a huge change from the early 2000 till now. Yes, the new younger lord, the young blood has joined in. They are also one amongst us. Some of them are near and dear ones of our own colleagues. Maybe their children, maybe their younger siblings. And most of them I've seen with their parents or their elder ones. They have seen them working, so they have adopted. They are calm and composed in the court. But the ones that have someone like me when I joined the profession, we feel, oh, maybe our client will not get the relief as is being sought. Maybe our clients deserve much better, or maybe I can completely destroy the case of the opposition. Please wait. There's no harm. There's no harm waiting. There's no harm in acknowledging the seniors. When I'm on the dais, it's a different me. I'm with the case. Please don't carry our grudges off the dais, off the place where we have argued our cases. There was a time when we started ki, oh, even if the opposite counsel is a senior or a colleague, the best part was, oh, we used to take it so aggressively if it is a fellow classmate or a colleague or a friend appearing on the opposite side. Once you are out, we would say, yaar, chai to pila de, coffee, canteen, in the canteen. Then you tend to see that the clients are wondering कि अरे ये तो they must have ये मिल गए होंगे. ऐसा भी नहीं है, हमने नहीं मिलना है. तो the only thing or the option we came or as a solution that we stopped requesting our colleagues or the seniors कि सर कॉफी तो पिला दो in front of clients, बाद में कि सर कैंटीन में प्लीज कॉफी तो पिला दीजिए. today you have won the case, or you had a better stand today than what I could do in the court case. Or even the seniors, they would say, yeah, you did a pretty good job. Come, let us have a cup of coffee. That's the beauty of the Delhi High Court. That the seniors that we have had, or we have at the moment, one of the finest. All of them have always been very supporting. There's, please, I would request all of us. There's, do not think we cannot approach them in case of any kind of, except in a case where they are appearing on the opposite side. There's no harm approaching them. They are more than welcoming, and that is what I have learned from them. Any person, any young or any other person approaching me for any kind of assistance on some matter or otherwise, and if it is within my knowledge or my ability, I'm always more than willing to help them. That is all I can promise to everyone. Feel free to come over, feel free to have a cup of tea. किस किस मैटर में क्या हो गया, क्या पंगा हो गया, क्या हम कर सकते थे, and nobody is billing you for that. Of what we have heard from the corridors of Supreme Court, here in the Delhi High Court, nobody is gonna bill you for a opinion or a advisory in the canteen or even otherwise. They are more than helpful. We have lawyers who have expertise in litigation, and they are always there to help you.
Uh, Hi guys, has the video paused only for me or is it for everyone?
It got paused. Even I thought that there might be some network issue. I switched my network.
Correct. So I was requesting my colleague ki something has happened on the side. So a complete, I think I've shared a lot. There's so much to say and so much I should curtail myself. Dhananjay ji, Keshav ji.
We got hooked into canteen.
Please, sir. So
Yes,
I
I think
request
that was the message from for me, that it is enough. You should pause now.
so there will always be a lot from you to learn. So it will continue.
Yes, please. So that's, I think I've taken a lot of time from everyone. Please tell me.
So I request everybody, whosoever has any question, may raise his hand, and or I put a question in the chat box, or directly ask to the sir.
Yes, sir. I
Alright,
want to ask.
put
Sir,
forward the
was
first.
Just
talking about that.
it is a small request from my end that before you ask, just switch on your video also, so that we can also see that who you are, and sir also can see. So please go ahead with your question.
Alright. So, so I'll put forward my question, sir. First of all, thank you so much. It was very enlightening and very nuanced, all the thoughts that you have shared. So one question that I have is that what is the relevance of the specific High Court rules, like you mentioned, the Delhi High Court rules, for any practitioner who has recently started practicing at the High Court?
They are the most important. Suddenly you find, see, LPA in a writ, or even the original side rules. Suddenly you find there's something that you can chamber appeals or otherwise, that is provided only in the Delhi High Court rules, which are not there on the in the trial courts on the original side. So a complete another Bible over and above the CPC that will have to, even on the criminal side and otherwise, it's another Bible we'll have to go through. Unfortunately, some of our lawyers who have also written books on the same subject, and otherwise, library is one place we all have to, one of the finest that we have in the country, and that is where I find earlier there was a. I remember when we joined, they used to be completely, it used to be completely filled. So we had to make that mezzanine floor as well, which was made later. But now still I see so many youngsters thronging, most of them for the SCC online and everything. I'm sorry, sir. Somebody was trying to say, ask him.
Yes, sir. I want to ask one question.
Are you
You were talking about the some lawyers get personally involved in some cases. In a matrimonial dispute, I faced this. We were representing the husband side, and on the contrary, uh, the lawyer of the opposite party got involved in some altercation in mediation with our client. So, how to deal with that problem?
See, that is one thing. I am as a mediator, I do not permit the lawyers to engage in any manner whatsoever. Even in the courts, even if we are present in the court or otherwise, we would request one of the lawyers. There's no question why do we have to engage or see in our times the one thing that the seniors told us very categorically, it is just one client. Don't spoil your reputation before the court and don't spoil your relations with your fellow colleagues at the bar for just one client. Please do not engage in any kind of a thing. Your job is to just represent your client and again make your submissions before the court. It is not even an inter se debate or a argument with the opposite counsel. No, me as an arbitrator, otherwise, ki, sir, please, there's nothing. Address us, whosoever is on the bench. We are not supposed to. That exactly my point when I said we are not getting into any altercation. If somebody else is, आराम से प्यार से request कर लो sir. मैं तो bench को I'm referring nothing between you and me. कि हम यहाँ पर client के लिए just making a submission. Please allow me to, or you may allow. I'll sit down maybe after that. Yes, that is exactly what I was referring to. Our especially our younger members are getting aggressive inside the courts. Please refrain. Please, a personal request. Please do not. It is at the end of the day, it is just one client, and he or obli she may stick to you. He obli she may not stick to you. Don't lose your reputation before the court. The court is someone amongst us is sitting on the bench, just like you and me are watching everyone. They too are. They would also make their opinions, and once an opinion made qua you, please believe me, you will have to work very hard if it is a negative opinion to get it on the positive or even a neutral. They are one amongst us. They know the laws. They know people very clearly. And again, we again, matlab for the rest, if you're joining the bar at 25, you have another 40 years minimum. Please do not spoil your so that you can't even meet an eye to eye with your opposite counsel. There might be times when you might be engaging him for your own setup or you might all be on the one side. Do not spoil your relationship. Thank you.
Please, sir, with your kind permission, can I ask one simple question, sir?
Who's this?
Sorry, sir.
हाँ जी बोलिए.
हाँ, sir.
I was asking who's on the screen.
Okay. So, sir, like we have original side High Court rules. They pertains to civil side, sir. Do we have any sort
I'm
of
also on the criminal side. Please go.
also? Okay.
Yes, yes, yes.
I was just a bit confused with regard to the criminal side also, that do we have any sort of different rules or the
Yes.
same rules applies? Okay.
No. Same rules, no. For the criminal side also. There are a set of rules for that.
Okay. Thank you, sir.
And that is one thing we all miss. Actually, when we approached the High Court, thanks to the seniors, they said कि जाके जरा डेली हाई कोर्ट रूल्स भी पढ़ लो, वो भी एक चीज होती है.
Good evening, sir.
हाँ तो अगर है तो there are some questions on the chat. Should मतलब am I supposed to take them here?
Yes, sir.
I request.
Dhananjay ji.
Yes, sir. Please. I request Sagar, if you can, if you wish to ask this question to sir directly, you can. If you want me to answer, ask this question on your behalf. I'll just put it to this
There's
sir.
one Karthik. What is the best tip for concise drafting?
Good evening, sir. Sir, I am
Yes.
Karthik, advocate, sir, from
Hi,
district
Karthik.
of Kurukshetra.
No, no, we are all lawyers. There's nothing called district court or high court, please. We are all lawyers. Today, I may be doing matters here. Tomorrow, I might be with you.
Yes,
So let us please remove that any distinction. We are lawyers. And one
yes,
just on the lighter side, I remember one senior advocate who went on to become a judge has retired. कहते यार हमें फीस दे दो हम तो एक पिलर से भी बहस कर लेंगे. So yes, Karthikeya, your question, please.
अच्छा सर मेरा क्वेश्चन ना ड्राफ्टिंग से रिलेटेड था कि ना कंसाइज ड्राफ्टिंग के लिए एक ना बेस्ट टिप सर.
Karthikeya ji, the only tip that I can give, please be very concise. Do not go into, I have dealt matters which have gone into 200 paras, 150 paras. Please don't, you will spoil your petition because
Yes,
para 33 will be contradictory and, as we say, no, self-defeating, contradictory to para 170.
yes,
Please ensure, when we started our seniors to tell not more than 3 pages. There's nothing that you cannot be concise for the reason, and that is a strategy also. Let the opposite side come up with more facts. They in their WS will have to come up with things, and then
yes,
you as a petitioner will always have the right to rejoin them in a rejoinder or a replication. Be as concise, be as concise of whatever I have learned from my seniors. और मतलब मे बी हमारा तो आंसर शीट भी उतना आधे पेज में खत्म हो जाता था.
yes.
जी.
Thank you so much, sir. Thank you, sir.
Sir, this is a question which I'm asking on behalf of Sagar ji. He's
जी.
asking that being an outsider, what should be our approach to set up our high court practice?
Completely with Sagar ji. There's nothing called an outsider. Delhi per se is a city of outsiders only. Delhi doesn't have any insiders per se. We have people from all over the country, and as has been time and again said by all the judges and the lawyers, Delhi High Court is one place. We have representations from all over the country. Even current president of the Bar Association the other day said, yes, he's from 3,000 kilometers away, and he has been so much loved by the members of the bar that he has been elected as the president here. Nothing outsider. What do you want? Join some office if you are fresh. You even otherwise, as I said, seek any kind of advice on the aspects of law from any person whom you feel comfortable is a senior or otherwise. We all are more than willing to help. We all are more than willing to help all our colleagues and members of the bar. There's nothing, if you ask me as a first generation lawyer, equally an outsider in the high court as anybody else would be. It is not just, and at times, many a times, I have one complaint which we always discuss in the canteen. कि यार ये outsiders, so-called outsiders in courts, they are doing much well than us. At least they work more hard than us, knowing people in the Delhi circles to get cases. हम यहाँ पे दिल्ली में सोचते हैं ना कि बस केस तो हमारे पास ही आ जाएंगे. I personally feel they work more hard. And fortunately, हमारे दिल्ली हाई कोर्ट में it is not like other courts, Gurgaon court, or that you have to have a local lawyer. So one of the best places where we do not require, you can straight away file your wakalatnama and argue your case. You don't need per se a local lawyer or otherwise, as it's being put to condition in Punjab, Haryana, or otherwise. That is one of the finest things that we have. You don't even have to, you just join an office, work hard. I still am always tell myself I need to work more harder. Some of my colleagues will be laughing on hearing me out here कि यार तुमने तो इतना मेहनत करी नहीं है. तो but there's no shortcuts. There's no shortcuts. There's no shortcut.
So, Smarika ji, go ahead with your question if you have any.
Smart.
Good evening, sir.
Yeah,
So
hey, smart.
myself, yes, so myself Smarika, and I'm a first year law student.
Law
So, sir,
student,
I
okay.
have, yes, sir. So I have two questions from you.
Please.
Sir, being a first year student, since I'm learning the basics, what should I start observing in the further court proceedings so that when I reach practice after 5 years, I already have a strong foundation for high court advocacy?
Marika, personally, if you ask me, I do not prefer first year law students who come to the court at all.
Hmm.
Please, there are subjects, abhi first year to you don't even have law as subjects. There are certain basics that you are being taught. Start, either you start studying or looking at the subjects of the fourth or the fifth year. Because you come to the court, the maximum you will see, okay, there are people in black and white wearing coats going to the court. You are just behind them. The thing that if at all, if you have time, say after your 5 p.m. classes, you can go to any lawyer's office. Start reading the files then. How an affidavit is made, how an application, what does it mean? Yeah, just a format. First year, I personally feel is too early for whatever your question is. You will not get any head or tail. If there is an arbitration case going on in the court, you will have no idea. Except कि एक arbitration case देखा था मैंने कोर्ट में, या मैंने क्रिमिनल केस देखा था, उसमें तो आधे टाइम तो कोर्ट के सामने कुछ बात हो रही होती है जो हमें नहीं पता चलता, कि वो तो लॉयर्स गए, बड़ी धीमी आवाज में किसी ने एक ने ये कह दिया, अब चलो हमने सुन भी लिया कि उन्होंने कुछ बोला कि सर ये कर दो, फिर पता नहीं जज साहब ने क्या ऑर्डर कर दिया. If at all, at least having an idea of how the file is being made, what is there in the file. And as I learned from my senior and other seniors, then if you see any section, pick up the Bare Act. For a first year student, still start picking up the Bare Act. It may not make much of sense in your first year, but by second, third year, you will get to know, "Oh, I remember that." Start picking up, reading the file if at all, if you are given that opportunity. If you're given an opportunity to how a diary is maintained, that is what we were being taught. How the dates have to be taken, how they are, now the technology is there, or you have those softwares where Google applications and otherwise where people feed it in their mobile phones and laptops. How to have a diary which would straight away define ki what is it. First, have an idea what a writ petition is. First, have an idea what an original side would mean, and why high court, and what is the difference between a high court original side or a district court original side. As I said, I started with that. I was very confused as to there's nothing much for me to talk on law with my fellow colleagues. Everybody knows rates, everybody knows CPC, CRPC, everybody would know their subjects. I was being told, whosoever I caught hold on to, कि यार क्या बोलूं आज, मैंने अब शाम को क्या बोलूंगा. Everybody knows what the law is. Today, the first and foremost, यार केस कैसे मिले, सबसे पहली join an office. Please, I have seen now all of us 6 months, maybe a year, and we suddenly go independent. Don't do that. I personally am not much in favor of. हमें, अगर मैं ओरिजिनल साइट की बात करूं, तो एक साल में तो डेट ही नहीं आती. प्लेंट के बाद WS की और एप्लीकेशन उसके बियॉन्ड. मैंने एविडेंस में क्या देखा नहीं देखा मुझे नहीं पता. You old 1 year is too less to go through that stages of a petition. Even a bail application, नीचे अब now they have said कि okay, you will have to file a status report filed even by the IO in the trial court. For someone like you, you have no idea what that would mean. Now it has changed. Now filing a bail, we'll have to file the status report in the bail application for a in the on the criminal side. Please, for you, join if at all you want to join. At the moment, confine yourself to the books. And if at all, if you're lucky, going to some office where you are able to read what it looks like. Initially, what is the feel of a file? कौन सा subject है? the registry would keep on changing the headings from a criminal miscellaneous. Now it has in a bail application becomes criminal miscellaneous bail application. They're constantly changing the nomenclatures. So for you to understand, there are nomenclatures. आप उसमें पहले आए. Section अगर आप पढ़ पाए तो wonderful. How much you will be able to understand it is something which you will have to work hard on it. And any other question?
Yes, sir. One
Thank,
more thing. Sir,
Yes,
I
please.
have been participating in some moot court competitions.
Mm.
So, which is again a faker version of the real court. So I was
No,
thinking,
it is completely fake. There was nothing close to being a anything
yes,
close to a
sir.
real code. Yes, please.
Yes, so I was thinking since you have been a part of the High Court, so I was thinking to ask a question. So, like, what do you think matters more, the thorough knowledge of facts or the ability to present the points concisely in the given time limit?
Both facts and law. Once you are comfortable with both of them, only then. Only then, for my learned friend who asked me being concise in the drafting of pleadings, the law is the paramount thing. Facts तो वही रहेंगे. It has to fall within the four corners or the parameters of the law. What I have to write, those judgments and the sections would tell me what. Even filing a police complaint today, please go through that section again and again. उसके ingredients sections के अगर आ रहे हैं, you have to ensure कि वो ingredients comply हो रहे हैं. अगर वो नहीं हो रहे तो criminal complaint आपकी कभी register नहीं होगी FIR में. उसके बाद आप 156 भी डाल लें, it is not helpful at all. Because police wala will come to the court, the prosecution, sir, it does not fall within the parameters. Very simple one-liner. Civil law, ये तो सर पता नहीं इन्होंने लिखा है, but the suit itself is not maintainable at the very threshold if it is not falling within the four corners of law. So we'll have to be very keep ourselves abreast with the law.
so
Yes,
thank you,
please.
sir, for your kind guidance and the insightful that you have shared it with us today. So with this, I seek your permission to close today's class.
Please, thank you very much everyone for
Thank
Keshav
you,
ji,
sir.
Dhananjay ji, thank you all the participants. Thank you for the questions. I do not know how much of help was this class per se, but thank you, Keshav ji, for forcing me to be a part of it. I kind of loved it. I had no idea I will be able to talk so much.
Thanks so much.
Thank you.
Thank you,
So
sir.
fine.
Thank you.
So, also just one final closing remark I want to make that obviously the world is filled with such amazing lawyers, guides and mentors as Sir, and how he took time to and I understand that a lot of people have a lot of challenges related to their litigation and when they want some kind of help. So in that case, I just want to guide you towards DSLSA, which is the District State Legal Services Authority. It is there everywhere in all districts in India. More so, I'll just tell you a little bit about Delhi's Legal Services Authority. So just one thing I want to mention is that phone numbers 15100 and 1516. If you ever have any problems, please just feel free to call them, and I'm sure that you will find some very good guidance for yourself. So, with that, thank you so much.
Thank you. Thank you. It was lovely catching up
Thank
with
you,
you all.
sir.
Thank you.
Okay.
Thank you so much, sir. Thank you.
Please take your Thank you so much, sir. Thank you, everyone. Thank you for participating. Thank you for joining. And we look forward to see you on Wednesdays and Saturdays, same time, 5 p.m. to 6 p.m.